Welcome to Inside IR, a podcast series by Herbert Smith Freehills Kramer that explores the latest developments in Australian industrial relations law and practice. Hello and welcome to Inside IR, the Australian Industrial Relations podcast, the series that arms HR, IR and legal professionals with the latest industrial relations thinking. On this 32nd episode of Inside IR, we are again dealing with the thorny topic of complexity in enterprise agreements. My name is Rohan and Doyle. I'm a partner in the industrial relations practice at Herbert Smith Freehills Kramer. And to help with this thorny topic, I have joining me today, Senior Associate Mitchell Brennan. Welcome, Mitchell.
Thank you, Rohan.
Mitch, we're welcoming you back, a sequel on Inside IR, because back on episode 25, you took our listeners through the difficulties of enterprise agreements and how unnecessary complexity within them was making it quite costly, time-consuming and difficult for employers to comply with them. And you made the case that given the increasing risk in this space due to additional regulation, higher penalties, increasing regulator activity, you suggested that it might be time to start doing something about this complexity. We know that enterprise agreements are, in many cases, a product of 30 odd years of enterprise bargaining, and there are many clauses within them that just simply don't make sense, and that makes it quite difficult to comply with. And you took us, Mitch, in episode 25 through some of the pathways that are available to employers to start resolving that complexity and simplify their agreements. Now, we're bringing you back for round two on this, Mitch, because there was a fascinating case handed down by the full court of the Federal Court in May 2026 that provides a pretty good example of the difficulties that can arise from complexity in enterprise agreements and where they can potentially stall or even prevent the implementation of workplace change initiatives. It's a case that went from the Fair Work Commission to all the way to the full court of the Federal Court. It involves enterprise agreement interpretation, it involves drug and alcohol testing, it involves a dispute resolution status quo clause that 4 separate judges and tribunal members interpreted in 4 different ways. It's got everything, Mitch.
It certainly does.
Let's start with that case. It's AMWU and Opal Packaging Australia. Tell us what happened.
Sure, thanks, Rohan. So we're dealing with a case involving Opal Packaging. They manufacture boxes across around 10 sites across the country. They brought the business from Aurora back in May 2020. And with that business came an alcohol and other drugs policy that allowed random testing, but it didn't spell out exactly how employees would go about being picked for testing. Under Aurora's stewardship, the practice had been blanket testing. You'd pick a site at random and test everyone there. But random testing was paused just before the sale because of the COVID-19 pandemic. And Opal kept it paused for over 3 years. In October 2023, Opal announced it was bringing back random testing, but instead of blanket testing, they'd randomly select a sample of employees at any given site. They also proposed a number of changes to the policy itself, and the Australian Manufacturing Workers Union said, no, we're in dispute, and under the enterprise agreement, you have to maintain the status quo while the dispute procedure is being followed. Opal went ahead and tested anyway at 3 sites in February 2024. Now, the clause at the centre of all this was clause 16.3 of the relevant enterprise agreement. It's a clause that will be familiar to a lot of our audience. It said that while the dispute resolution procedure is being followed, work shall continue normally and the status quo will remain. It also said that work in the affected area would remain as it was at the initiation of the dispute, and that no employee's duties, shift, occupation or income would be changed during this process.
Great, thanks, Mitch. And so, essentially, we have an employer wanting to recommence drug and alcohol testing under their existing policy, but perhaps in a slightly different way to which they'd been recently applying that policy, and a union saying, well, we don't agree that you can do that. We're in dispute. The status quo clause means that you can't proceed with implementation of that change. Is that a fair summary?
That's a fair summary, Rohan.
So what happened next?
So this went through 3 forums, 4 decision makers, and each one took a slightly different approach to the clause, which really shows you just how tricky this language was. First up was Deputy President Masson of the Fair Work Commission in July 2024. The Deputy President approached the construction of the clause by assessing whether Opal's policy changes constituted a lawful and reasonable direction. The Deputy President found that Opal's consultation process was deficient, so was prevented from implementing the policy changes and from using sample testing, but wasn't ultimately prevented from bringing back random testing altogether. Then the Federal Court, where Justice Bromwich handed down judgment in August 2025. His Honour found that status quo remain simply reinforced the preceding words, work shall continue normally, meaning the clause was really only about employees continuing to do their work and not about restraining what the employer could do with its policies or practices. And His Honour dismissed the union's application accordingly. The union then appealed to the full Federal Court, where Justices Raper, Hatcher and Longbottom handed down judgment in May this year. All three disagreed with Justice Bromwich's construction, but the appeal was still dismissed because of new arguments that Opal raised on appeal.
So I'm interested in that timeline, Mitch, because I think you mentioned July 2024 was the first decision of the Fair Work Commission, is that right, on
Yes.
the dispute? And so, I mean, in this case, it was a scenario where the employer had already implemented the change and the employer was successful in the Fair Work Commission and then again successful at first instance in the Federal Court. But you could imagine a different scenario where the employer was proposing to implement change, the decision went against them in the Fair Work Commission and they were the party that had to appeal. It could have been a scenario where the employer was actually waiting to implement the change for this entire period. Is that a fair assumption?
Yes, that's right.
Yeah, so I mean, that with different facts, you could have quite a delay to implementation of this change. I think we'll come back to that point a little bit later. But just to reinforce this point, the three judges of the full Federal Court didn't agree with the reasoning of the Deputy President of the Fair Work Commission or the primary judge in the Federal Court about how the status quo clause was to be interpreted. Is that right?
That's right. And this really is the key point. The majority judgment of Justices Raper and Longbottom found that neither party's construction was correct and that the construction adopted at first instance didn't reflect the proper meaning of the clause. The way the majority read it, the clause operated to preserve things as they were at the point in time when the dispute was initiated and not anchored to some earlier point when the subject matter of the dispute arose. So, the clause didn't stop the employer from continuing something it was already doing before the dispute began, consistent with existing policy and practice. Justice Hatcher saw things a little bit differently, though His Honour got to the same place on the facts. His Honour gave the words status quo remain independent and broader meaning. He said that the status quo goes beyond employees just continuing to do their work, and it can actually require an employer to hold off implementing operational changes while a dispute is on foot. But here's the key thing. On the facts, both the majority and Justice Hatcher agreed that Opal hadn't breached the clause because the policy always permitted random testing. The pandemic pause was just that, a pause, not a settled practice. And the union couldn't point to a clearly identifiable existing practice about how testing was supposed to be conducted.
So if we apply His Honour Justice Hatcher's view to interpretation of those provisions, Mitch, then if Opal had a slightly different policy and was looking to actually change the words of it and materially change what it was able to do under that policy, then again the outcome would have been different, wouldn't it? It would have been a finding that, well, actually this status quo provision prevents you from making that change until and unless the dispute's resolved.
The status quo was when the subject matter of the dispute arose, not when the dispute itself had arose, yes.
Yeah. And so what we have here, which is one of the more fascinating aspects of this dispute, is you have 4 different judges or tribunal members that have a different view as to what this clause does and how it operates. And those 4 different views are again different to the 2 parties that were involved in the case. So in essence, you've got 6 different approaches to interpretation of this provision, which is quite a result, isn't it?
And it is, and it just shows you how much can turn on imprecise language in an enterprise agreement. And this is a type of clause that appears in thousands of enterprise agreements in one form or another, yet when it was actually tested, it generated years of litigation across 3 forums and produced different answers at every level.
Yeah, it's a good call out, actually, and we are not in the slightest being critical of the parties or the court process or any of that. To the contrary, I think you've got to have a fair bit of empathy for the people involved in cases like this, because quite simply, it shouldn't be this difficult for employers to understand what obligations it has under its enterprise agreements, particularly when it comes to the implementation of policy changes or workplace change. And the cause of this complexity, as you've pointed out, Mitch, is the enterprise agreement. But it's a clause that is quite common. It's been in this employer's enterprise agreements for a long time. Very similar clauses appear in other employers' enterprise agreements across the country. And so this isn't an isolated incident. It's not a niche case. It's something that I think all employers should take some notice of. And I mean, Mitch, we're frequently talking to our clients about simplification of their enterprise agreements and the benefits involved in that, stripping out clauses like this, or at least including some clearer provisions as to how they're intended to operate. What's at stake here for employers?
Let's start with the most obvious one, civil penalties. This case was a civil penalty proceeding. The union wasn't just asking for a declaration. They were seeking pecuniary penalties against Opal for contravening the Fair Work Act. If you breach a term of an enterprise agreement, including a dispute resolution term, you're exposed to civil penalties. Now, Opal won this case on the facts, but imagine a slightly different scenario. An employer who implements a new roster or a new policy after a dispute has been initiated in circumstances where there is a clearly established prior practice under either the majority or Justice Hatch's construction of the relevant clause, that could be a contravention. And the penalties are not trivial. And the broader context here is also important, and something that you touched on at the start, Rohan, which is since the closing loopholes reforms, the stakes have gone up significantly. The whole compliance framework has been tightened. In that environment, ambiguity in your enterprise agreement isn't just an inconvenience, it's a genuine legal risk. If you can't tell what your clause means, you can't be confident that you're complying with it. And if you're not complying with it, you're exposed.
Yeah. And penalties are important, of course, Mitch, but it's not the only issue here. There's a bit of an operational, practical dimension to this as well.
Yes, and this is one that should really get employers' attention. Think about what a broadly drafted status quo clause actually does in practice. If a union can initiate a dispute about a proposed workplace change, and the status quo clause then operates to freeze the employer's ability to implement that change until the dispute resolution procedure has run its course, you've effectively given the union a veto, or at least a very long handbrake, over operational decision making. And look at what happened in this case. The union initiated the dispute in late 2023. The commission arbitration wasn't until May 2024. The federal court proceedings ran through to August 2025, and the full court appeal wasn't decided until May this year. That's 2.5 years from the initiation of the dispute to final resolution. Now, Opal went ahead and tested in February 2024, and that's what generated the civil penalty proceedings. But if they'd complied with the clause as the union construed it, they would have been locked out of conducting random drug and alcohol testing for 2 years while the dispute wound its way through the system.
Yeah. You can easily see that happening in a different case with different facts, can't you, Mitch? That's a distinct possibility.
Very much so, Rohan. Another point to make here is that Clause 16.1 of this enterprise agreement defined dispute very broadly. It covered disputes about any workplace industrial policy, practice or procedure, and disputes about any proposed amendment to a workplace policy or procedure. So the scope of what can be put in dispute, and therefore what can be frozen by the status quo clause is enormous. And under Justice Hatcher's construction, the status quo obligation would require an employer to refrain from implementing operational changes while the dispute resolution procedure is being followed. His Honour acknowledged this would involve a significant restriction on the capacity of the employer to make operational changes. Now, that's a direct quote from the judgment. If your enterprise agreement has a clause like this, and a union initiates a dispute about a proposed change, you may find yourself unable to implement that change for months or possibly years while the procedure plays out.
Yeah. And I mean, it's important to note, Mitch, most of our listeners will know this, but status quo clauses are not mandatory enterprise agreement terms. They are common just by virtue of history and them having appeared in industrial agreements for a long time. But also your point about the scope of the dispute resolution procedure, that's important too. It doesn't necessarily have to apply to all disputes in relation to the employment relationship. It can be narrower. It only needs to apply to disputes about the application of the agreement, the NES. So employers do have some choice there.
That's right. And the broader the clause, the more leverage it gives to anyone who wants to slow things down.
That's right. So what's the answer here, Mitch? I mean, what do we suggest employers do to protect themselves and make their compliance task easier?
Rohan, the answer sounds deceptively simple, and that's make your enterprise agreement terms clearer. First, review your dispute resolution clause. Don't wait for the next round of bargaining. Gain an understanding of what your current clause says, how it would be construed in light of the full court's judgment, and what the practical implications are for your business. Second, and this really goes to enterprise bargaining, it's to be deliberate about what you're agreeing to. If you want a clause that simply requires employees to keep working while the dispute is being resolved, say that and only that. If you're prepared to accept a broader obligation that restricts your ability to implement changes during a dispute, that's fine. But go in with a clear understanding about what it is you're agreeing to and make sure that the clause spells out exactly at what point the status quo is engaged. Don't leave it to the commission or to a court to work out whether status quo means the state of affairs at the initiation of the dispute, as it was found by the majority in this case, whether it's at some earlier point, as was contended by Justice Hatcher, or something else entirely different. Third, think about the scope of your dispute resolution procedure. The scope of the dispute resolution clause in the relevant agreement was very broad. It covered all matters which pertained to the employment relationship between the parties. That meant almost anything could be put in dispute, and therefore almost anything could be frozen by the status quo clause. Employers should think carefully about whether that breadth is appropriate or whether the status quo obligation should be confined to a narrower category of disputes. And fourthly, document your practices. Even if your clause is imperfect, you can protect yourself by maintaining clear records of what your policies say and how they've been applied. So here in this case, Opal's new arguments on appeal were successful because the union couldn't establish a settled practice. That's a factual defence, and it depends on you having good records.
Yeah, they're good tips, Mitch, and I think increasingly important. I make the case that historically it was common to have these status quo clauses and broad disputes procedures in agreements. I think historically they were a lot more manageable. I mean, change was less frequent, less significant. But if you think about the world in which we're living now, we live in a world where the pace of change is increasing. You have geopolitical issues, you have technological change through AI and the like, you have changes in societal expectations, you have employer challenges to the cost of their operations, to revenue. You have, the list goes on, you have all these shifts that are occurring. These aren't short-term problems. We're in a world where this pace of change is going to forever increase. And what it's requiring employers to do, I think, is be a lot nimbler in terms of how they respond to these changes. And it's requiring them to make more frequent and significant changes than perhaps in the past to adjust their businesses to confront these challenges. And I think if you think about an employer that has these broad dispute resolution procedures, compulsory arbitration, and a very broad status quo clause, you're building in a lot of extra time to implement all of these changes, whether it be to policy, to work types, to labour structures and the like. Not only do you have to consult the major workplace change, you then, if there's a dispute, have to wait until the dispute's resolved. You've given us a very clear understanding of the timeline. In this case, Mitch, it's not a short period of time. And if your competitors don't have those restrictions, you're just inevitably going to be moving much more slowly than them. So I'd make the case that it's more important than ever to have a closer look at these provisions and reflect on whether they remain appropriate for the world in which we're operating now. As Mitch said, if you do have them, give some thought to whether it might be worth removing them, or at the very least, if they're unclear, building in some clarifications so there's a common understanding amongst everyone, unions, employers, employees, about how they're intended to operate. Now, we should say, Mitch, we don't pretend for a second that's going to be easy to negotiate in the context of a bargaining round. We know that union preference is going to be to maintain the breadth of these provisions and resist change. But I do think my personal view is that it's time for employers and unions and employees to perhaps work together a little bit more on this simplification objective. It's just simply not good enough that it requires so many years of litigation for employers to understand what they're allowed to do or not do under the terms of their instruments. And I think it's in everyone's interests that some time and energy be invested in starting to make all of that a bit simpler for everyone.
And I think, my overarching message is this: enterprise agreement clauses that look routine or standard can have enormous practical consequences. This case involved a dispute resolution clause, but the same principles could be applied to consultation clauses, to flexibility clauses, and any other provision that touches on the employer's ability to manage its business. In a world where the penalties for getting it wrong are higher than ever, and where unions have significant leverage to slow down workplace change through dispute resolution procedures like this one, clarity isn't a nice to have, it's an essential. And the time to fix these clauses is preferably at the bargaining table, not in the commission or a courtroom.
Yeah, I think that's right. And what it also does, Mitch, I think, is really show the value of explanatory materials that employers prepare ahead of votes. I mean, even if you're not making changes to clauses, so much value in adding some detail to those explanatory documents that explains how the employer sees these provisions operating, because as we know, that's then admissible material in any dispute that then arises, and might just find that makes that whole process a little bit more straightforward. But thanks so much, Mitchell, for round 2 of complexity in enterprise agreements. Some really helpful tips there. And whilst I think this decision was fascinating in terms of status quo obligations and how they're to be interpreted by a court, it's got some more general importance there in terms of lessons for employers on how to approach complexity in their enterprise agreements. As always, we'd love to hear feedback on Inside IR. If you have any feedback or even suggestions for some topics for future episodes, please let us know. Feel free to comment on LinkedIn or send us an email at insideir@hsfkramer.com. Otherwise, thanks for joining us, and we look forward to you joining us on our next episode of Inside IR.